Welcome back, everybody, to another episode of Ask A Beaver Anything. It's Tony P from Viva Las Vegas in the home office here. Great to see all of you again. I hope you're recovering from the disappointment of Saturday. And hopefully you dried out by now because it was wet. And I came all the way to Vegas, from Vegas to the game. Tried to connect with my bro Alan here, but we just couldn't make it happen. But nonetheless, got wet, watched the game, should have won. But now here we are to talk about the Washington State Supreme Court. Alan, take it away, brother.
Well, as disappointing as that game was, I guess the most important result last week in contest against the University of Washington was in Judge Leiby's courtroom. And he ruled on two motions and ruled in Oregon State's way in each of them. And long term, despite the disappointment that we all feel, it would be a lot worse if we had lost either of those motions. Fortunately, we didn't. So today, Tony, what I want to talk about is what is happening before the Washington Supreme Court. How is that going to impact Oregon State and Washington State? How will that impact football during the upcoming transfer portal? And what is going to happen to the Pac-2? And I prepared some nifty little slides to go with this. So the first question is, what is before the Oregon Supreme Court? As indicated on November 14th, Judge Leiby ruled in favor of Oregon State and Washington State in two motions. The first one was a motion by the University of Washington to dismiss the case. If that motion had been granted, this all would be over. And the second motion was on Oregon State and Washington State's motion for a preliminary injunction. And as viewers will recall from prior episodes, a preliminary injunction covers the time from now until the end of the lawsuit, when there is a trial and a final judgment. This is not the end. This is just the continuation of the beginning. And fortunately, the judge ruled in our favor there as well. So the very next day, on November 15th, which would have been last Wednesday, the University of Washington filed a notice of appeal. And their notice said that they were appealing both decisions, the motion to dismiss and the motion for the preliminary injunction. The very next day, the Court of Appeals, the Washington Supreme Court, entered a temporary stay so that the Judge Leiby's ruling does not go into effect until after the Washington Supreme Court has an opportunity to weigh in. The very next day, on Thursday, the 17th, no, it must have been Friday, the 17th, Oregon State and Washington State filed a motion to accelerate the decision on the stay. And that's where we are today. Interesting, and maybe only lawyers who watch this will find this interesting, but I'm a lawyer, so I find it interesting. Something you never, ever see in an appeal before any Court of Appeals or Supreme Court is that both sides are essentially represented by the same law firm. And the law firm in this case is the Washington Attorney General's office. Never seen that before. Probably won't see it again during my professional career.
Wow.
That is where we happen to be. So there's the court set a timeline. So November 14th was the trial court decision. November 16th was the University of Washington's motion to stay. On the 17th was the deadline for Oregon State to file an answer to that motion for stay, and Oregon State has done so. The motion to stay and Oregon State's answer very closely mirrored the arguments that were made at the trial court before Judge Leiby in the various briefs that were filed in that case. November 22nd, which is tomorrow, the University of Washington is to file their reply to Oregon State and Washington State's answer. So we'll be looking forward to that tomorrow. And then on December 4th, that is when the court said it will make a decision on or before that date. But, and here's the important thing, it is merely a decision on the motion for stay. It is not a decision on the merits of the motion themselves.
So what does that mean, Alan?
Well, what that means is the court could do a number of things. One is it could go, this is a discretionary appeal. We don't even want to hear this yet. Let it run through the trial court. Let it go to trial, and then we'll take a look at it. That's one possibility. Another possibility is they could say, well, we're going to take the appeal, but we're not going to grant the stay. So Oregon State and Washington State, you can move forward as the board of directors of the Pac-12, as Judge Levy ordered. And then while you're doing that, we will decide the motion on the motion to dismiss and on the preliminary injunction. Or the court could say, no, we are going to extend the stay, and we will release that stay after we've had a chance for briefing and argument on the University of Washington's motion. So it could be anything from an outright victory to extending the stay while the appeal is heard.
So ideally, what we're looking for is no stay. And even if they grant the ability to appeal, things move along. It falls back to the lower court's decision, correct?
Correct.
Okay. And we should know that by the 4th. Dave Hopkins wanted to know how long you expect this to last prior to the ruling or settlement. And he feels that it sounds like Washington and the other 9 are trying to drag this out to the football transfer portal date of 12/4 to pressure Oregon State and Washington State into giving them all or at least a share of this year's revenue.
I think David is right about the strategy of the University of Washington and the Pac-12 and the Pac-12 commissioner to try to stall things out. The longer that they are able to delay this, the longer it will be before Oregon State and Washington State can start making plans for the future and start spending money for their plans for the future. So the longer it is delayed, the less money will be spent for the future, the more money will be available for annual distributions. I think he's right on that. I don't think they're using it necessarily as leverage tied to the transfer portal. I could be wrong on that, but they certainly are trying to stall things. And in fact, and I made comment about this in other places, on the University of Washington, or excuse me, on the Pac-12's argument before Judge Levy, they basically said the current TRO process is working well. And under that process, no decisions can be made without the unanimous consent of all members. Well, that may be good for University of Washington and that school that happens to be located in the city where I live, which is Eugene. But it certainly is not good for Oregon State and Washington State trying to prepare for the future. So that was the Pac-12's argument. And they're making that same argument in the briefs that they have filed so far with the Washington Supreme Court. David is absolutely right. It's just part of a pattern of trying to delay. And I think they're trying to run the clock out.
run the clock out through the end of well, up to August 1st.
Yes.
Yeah.
If they can, or at least as long as they can.
Right. Do you think the Washington Supreme Court will be the final ruling on this?
Yes, no, maybe.
You really are a lawyer, aren't you?
Well, it's the posture. The case has not been decided. It is very early on in the case. There has been no trial. The trial is probably a year away. So in theory, no, this is just a ruling at a snapshot in time as part of a much bigger trial. I say yes, if they rule against Oregon State, then this case is over. And so unfortunately, it could be a final ruling.
Now, if that happens, you're saying basically then the 10 schools can kill the entire conference.
Maybe.
They can destroy it and split it up, and that's it. We don't have any way of keeping the conference alive.
That would be subject to further litigation. That would certainly be subject to further litigation. But then it becomes a case about money.
Sure.
And that's bad for Oregon State and Washington State because we're trying to preserve a conference. We're going to look for others to join us in this new conference.
Right.
We want to make an argument that we continue as an autonomous conference, which means certain NCAA rules do not apply to the 5 current autonomous conferences. We want to maintain that. Right. So there's a lot of other attributes of the conference beyond money, which appeal to us. And I think that strengthens our case before the Washington Supreme Court.
Sure.
Because Washington, it's about money. For us, it's about something more.
Right.
If Judge Levy's rule goes into effect, and then when they get to trial, they go, no, you should not have had an injunction, and we're going to deny a permanent injunction, and you lose that trial, well, then it becomes a question about money. But if we are right, it's about more than that. And that, I think, was a big driver at the motion stage before Judge Levy. And I think it will continue to be a driver before the Washington Supreme Court.
So Peter Baker, another one of our followers, said that he's seen a fair amount of press since UW filed for a temporary stay, stating that the deserting 10, as he called it, could get more favorable ruling in the Washington Supreme Court because of its location. Could the court render a biased decision in favor of the defendants?
So I've seen some of those articles as well, and these are by reporters. These are by sports journalists, and they don't really know anything about the Washington Supreme Court or probably the legal process. The number of miles away from the University of Washington isn't a big factor. I looked at the makeup of the Washington Supreme Court. I read the bios of each of the 9 justices. There's 2 men, there's 7 women. They are accomplished individuals, and for the most part, they are concerned about issues of racial justice and LGBTQ issues and access to justice and other big pressing community issues. And I think for many of them, they're not going to be particularly interested in what happens to athletics. And I'm not sure this is a big deal to them. 2 of the justices did go to undergraduate college at the University of Washington. One of those and 2 others did go to law school at University of Washington. One went to law school at USC. Another went to law school at Berkeley. But I can tell you that graduate school has nowhere near the tug on your loyalties, particularly when it comes to athletics, as your undergraduate college.
Certainly.
One of the justices went to Gonzaga for both undergraduate school and law school. She grew up in Western Washington, and I don't know if growing up in Western Washington makes you a WSU fan or not, but she didn't grow up in Seattle. We know that. I think it's a discredit to those judges for those sports reporters to make that suggestion. I think it just shows they don't really know what's going on.
You've said it many, many times. Nobody knows but those people in the middle and are in behind the doors and the smoky rooms. Now, I know in certain other courts, like the Supreme Court, for instance, of the United States, they can have a panel that would take the ruling, or that could make the ruling versus the en banc, I believe is the term, right? So they all get involved. Is that something you think would be like a 3-judge panel of the Washington Supreme Court to make the ruling, or do you expect the entire Supreme Court, all 9 of them, to weigh in?
So the panels are part of courts of appeals. So for the Supreme Court of the states, at least the states I'm familiar, and the United States, the entire court hears the appeals. So people have asked, how long will it take until this case makes it to the Supreme Court, U.S. Supreme Court? This case, it's not getting to the U.S. Supreme Court. Now,
Right.
The University of Washington argued that the Washington court doesn't have jurisdiction, and the only way to do it is to treat it as a case between states. And then those cases, the original court of jurisdiction is the U.S. Supreme Court. But the court rulings have made clear that not all disputes between states make it to the U.S. Supreme Court. A contract dispute between universities in different states is not the type of case that makes it to the U.S. Supreme Court in
Right.
original jurisdiction. So the University of Washington's argument was totally shot down by Oregon State's lawyers in the briefs. During the hearing, it was brought up by the University of Washington, but it was so effectively destroyed in briefs and never countered by the University of Washington that Oregon State's attorney didn't even feel that it needed to address the University of Washington's renewed argument during the oral argument. Didn't even want to waste their limited time on that. Now, other cases, though, can also make it to the Supreme Court. But when a case makes it to the Supreme Court, they have to go all the way through the process. So when a case starts in a state trial court, there must be a ruling in that case, must be a judgment. Then it must go to that state's court of appeals. Then it must go to that state's Supreme Court. Then it must go to the U.S. Court of Appeals. Here it'd be for the Court of Appeals for the Ninth Circuit. And then, only then, can they petition the U.S. Supreme Court to hear their appeal. And you have to convince the Supreme Court that this is such an urgent issue facing the nation, or there is a conflict between the circuit courts across the nation, that the U.S. Supreme Court should spend their limited time on that. You must also, though, show that the case involves an issue of federal question, federal law. This is a contract case. It involves around state law. It's not getting to the U.S. Supreme Court. It's not getting even to the Ninth Circuit Court of Appeals, I don't think. And even if it did get to the Ninth Circuit Court of Appeals, we're talking years down the road. By then, it's all moot, and we're moving on. So it's the University of Washington who brought up the issue of the U.S. Supreme Court. I think that's confused people. It was a nice try by them, but no cigar. And now we're just moving on to we're moving on with the case and hopefully the Washington Supreme Court will get the decision right, and we can move forward.
So I think you touched on this a moment ago, but there's three different options. It sounds like they can issue a stay, a quote unquote permanent stay or extended stay to let the case actually go before a jury and etc. In which case nothing happens. It stays exactly the way it is. And
so
they can't do anything. And then there's the chance they could rule in the defendant's favor and basically end the temporary injunction and rule and say, nope, all the people in the conference are part of it and they all can make a decision by majority rule or whatever, right? And then there's the other option where they can say, no, you don't have a stay, but you can go to court. But in the meantime, the ruling of the lower court goes into effect, and Oregon State, oh my God, what did I do? Washington and Washington State can proceed with business as usual for the conference. And I think that covers it, right?
Yeah, the Washington Supreme Court can say, no, we don't even want to hear this case yet. It's too early for us to hear this case.
Right.
So therefore, we're not going to hear the case, and the temporary stay is removed. Or they could say, yeah, we'll hear the case, but but we are going to remove the temporary stay and let the preliminary injunction go into effect. Or they can say, no, we're going to hear everything and we're going to leave the temporary stay in place.
What do you think is likely?
Oh, I think it's likely that the Washington Supreme Court decides, yeah, we're not getting involved in this. I think, and I'm hoping that Oregon State will win on the 4th. If not, even if it does go to full argument on the two appeals, I'm really confident we win that. It's just because the legal arguments are the same. I've read the briefs that have been filed with the U.S. Supreme Court, and they're making the same arguments. And they were winners once, and I think they'll be winners again. Something else too, and it's the standard of review. So for the appeal as to the injunction that puts Oregon State and Washington State as the directors of the Pac-12, the standard of review is abuse of discretion. So it means the trial court Judge Levy, abused his discretion. And how do you measure that? Well, if reasonable minds could disagree, then there is no abuse of discretion. That's a very high standard for the University of Washington to make, and a very favorable standard for us. So what do I think?
I agree. And they would have to, right? They would have to look at it. And I believe we talked about that before. It's like, is the ruling that he came up with absurd on its face, that it would require them to say no, and you need to go forward. I mean, it does feel like definitely the odds should be well in our favor, based on everything, like you said, all the evidence that's been provided, the statements, everything by the attorneys, and the statement from the judge that gave the ruling. It would feel absurd that they would. So.
Yeah, the standard of review on the motion to dismiss is a lower standard. And there, the Supreme Court makes its own decisions as to the applicable law. And I think even at that lower standard on the motion to dismiss, we will carry the day, or not we, because neither of us are involved in the court. But Oregon State's and Washington State's lawyers, I think, will carry the day on that.
So December 4th, are they going to get the ruling done before December 4th and, allow us to finalize our schedule, or not be affected by the transfer portal?
I think those are two issues. And a lot of people are concerned about there being a stay when the transfer portal opens. I don't think it makes any difference at all. Oregon State and Washington State, they agreed to the schedule of the Whitman County Circuit Court. They stipulated to that. And they knew when the transfer portal was, and they knew about the possibility of appeal, and they know how long it takes for an appeal. And in their brief for expedited consideration of the stay, they talk about the importance of getting in and taking control of the conference and planning for the future. They did not mention a single word about the transfer portal. The more important thing for the transfer portal is the football schedule. And I wouldn't worry too much about what the Washington Supreme Court decides and whether that happens before December 4th or after December 4th.
What do you think the schedule is going to look like?
Well, I know what I don't think it's going to look like. But my guess is it will include some Power 5 schools, and it will include some Group of 5 schools. The Group of 5 schools may be primarily Mountain West schools. But even if we have some sort of a scheduling partnership with the Mountain West, we will not, and I can't emphasize this enough, we will not enter into an agreement that requires us to merge with the Mountain West at the end of 2 years. You've seen reports mostly by a guy from Yahoo Sports, who his information was coming from sources within the Mountain West. And that is the Mountain West dream. And I don't think it's happening. I don't think it's happening at all. And why would it? The Mountain West has a $37 million exit fee. The goal with realignment is to survive and position yourself for the next round of realignment. If you're in the Mountain West, the goal is not to stay in the Mountain West. And why would you agree to a $37 million exit fee when you're only getting $4 to $5 million a year in media shares? That makes absolutely no sense.
Right.
And I do happen to know that the folks at Oregon State and Washington State are well aware of that.
100%. So another friend, Victor Cesarani, I hope I didn't butcher that name. It could be Cesarani. Wants to know if you think there is something to the new discovery phase, and are you optimistic about what will come out of that?
Well, I would think, I don't know if you could hear that. Someone is revving their engine on the street behind me. I would think a good Italian boy with the name of Pulicella would know how to pronounce Victor's last name.
Yeah, I butchered it at the first go. It should be Cesarani, but what can I say?
So what else is happening in the case? What I hope is happening is that Oregon State has already sent out subpoenas to the 9 wretched traitors who are not part of the case, sent a request for production to the University of Washington, who is part of the case, and send subpoenas to the 3 conferences that have been pillaging the Pac-12, and sent subpoenas to the sports media overlords. And they are looking for information and statements to support possible claims for antitrust violations or other embarrassing and potentially damaging issues.
Yeah, no kidding.
And so to Victor's case, yes, there is a new discovery phase. This is very important, and hopefully it will be this discovery phase that gives Oregon State and Washington State leverage as they work to rebuild the conference. And yes, I'm optimistic about it, by the way.
You think there's a chance that we could get picked up by a power conference as a result of winning the case, like the Big 12? Samantha Heibenthal would like to know that.
I don't think winning the case gets you to an invite to one of the remaining power conferences, the Big 12 or the Big 10 or the ACC. I don't think we'd want to join the ACC. I don't even think we want to really join the Big 12. Currently there are 68 power conference members, universities, 68 schools, and Notre Dame, which makes 69 total. And if you believe the reports that have been read, and they seem to be well sourced, ESPN and Fox, they want to narrow this down to about, I don't know, 24 to 34 schools, and they put all the money into this top tier.
Right.
Well, the schools in the Big 12 are not top tier. And I think the Big 12 is one of the next to get lopped. And the same is true with the ACC. They may pull a couple of the universities over to the SEC, and then the ACC is relegated to a lower status. So
100% on that. 100%. I mean, FSU, Florida State, Clemson, North Carolina, Miami. Those 4 schools are gone the minute they can get there.
And so if Oregon State were to get an invitation to a power conference, it would be through the discovery and through the threat of discovery and through the threat that Oregon State and Washington State could disrupt college sports. That's how that will happen.
So Jim Steers wants to know, can the liabilities be tied to all 12 schools as they were incurred in the past?
Well, let's hold on to that question here for just a moment, because a number of people have asked, what's the first thing you would do if you controlled the Pac-12? And Tony, I might ask you that question. If you were President Murphy from Oregon State, and you were one of 2 directors for the Pac-12, what's the first thing you would do?
Quite honestly, I think I just try and button this whole thing up. I would make it so that any liability incurred during the current year or previous years are shared by 12.
That's coming up. That's coming up here in a moment, Tony.
You asked me what I would do. I would just make sure that was done, that there'd be an even split of the revenue to date or through the end of the year. And of course, I'd fire George K. for sure. He'd be the first one to go.
And that a lot of people say the first thing they would do is fire George. And I thought about it and I go, maybe that's the second thing they ought to do. I think the first thing, the most important thing that Oregon State and Washington State should do is rebrand the conference. So they're known dismissively as the Pac-2. That's terrible. It's the two that no one wanted, and we ought to be looking towards the future, not the past. And I would rebrand it something such as the Pac-X. It's really kind of silly that the Big 10 has 14 members and will soon have 18. The Big 12 has 14 members and soon will have 18. The Pac-X recognizes that, this is the future, baby. The number of members of the conference are going to change over time. Hopefully they're going to increase. And it really takes it from a negative to a proactive looking forward. Whether they call it the Pac-X or something else, they ought to rebrand.
As a lot of people are going to argue with that. I mean, that, as the conference itself, it can be renumbered, but I mean, and I don't know if you rename the conference, does that mean all past championships and everything like that are no longer affiliated with the existing conference? I mean, there's something to be said for that. All the historical stuff would essentially go away and you'd start at 0, I would think.
No, you're still the same conference. You've just changed your name. We've changed the name many times, from the Pacific Coast Conference to the Pac-8 to the Pac-10 to the Pac-12. It's still the same conference. You've just changed the name. Branding.
I like the idea of it being the Pacific West, if assuming we are going to stand and complete things the way that the presidents have said in this argument, saying that it's about student welfare, mental health, all those things, to not be traveling cross country, and especially with the Olympic sports and things like that, that they have to think about the athlete as a human being and as a student. So if that's the case, I mean, you've really kind of planted your flag there. It would be foolish, I think, and going back to your previous question, should they join it? I don't think they should. I don't want to see us in the Big 12. I don't want to see us part of the ACC. I want to see us rebuild it. And if we do kind of cannibalize or create a new entities based on the regionality, Pacific West would be a good name. But anyway, that's an interesting interesting thought, that the first thing you do is come out with a whole new branding campaign. I will say that those things, to do them right, since that's my bailiwick, it's extensive, and you really got to make sure that you have a lot of things already figured out if they haven't already started. But even if they had, a complete rebrand is something that can take a good year to do it properly. So anyway.
Well, Oregon State and Washington State, it's been reported that they have engaged a marketing firm, and I hope those reports are true. And I would argue they don't have a year to wait. They need to start generating excitement. And Oregon has shown what branding can do, and they're reaping the benefits of branding. They are a national brand, and whatever the conference is, I think they need to become a national brand, not a regional brand. And I think we ought to brand our budding rivalry with Washington State University. The game between brothers. But I would have some fun with that. Maybe get Allstate as a sponsor and call it the Mayhem Game. In fact, Michael Chambers suggested that, when I threw out the Mayhem Game earlier, Michael Chambers suggested that we could have a tug of war contest between WSU students and Oregon State students across the Columbia River, either before the game or at halftime. How cool would that be at the Bridge of the Gods, a made-for-TV location? We are behind in the branding game, I believe, and it's a little odd for lawyers to be talking about branding because we're among the worst. But we need to jumpstart this, and we have interest, we have attention. It is time to capitalize that, and hopefully folks are thinking about that.
Well, I think you're right, and quite honestly, though, it does help push momentum in our favor along the way, especially if we get a initial ruling or a secondary ruling to say no stay, injunction stands. Now, then it really needs to, like you said, you get the ball going down, that snowball going downhill, and it'll be almost impossible to do anything to stop it. So the question then from Mr. Jim Steers: can the liabilities be tied to all 12 schools as they were incurred in the past? Question mark.
Hopefully, yes. And that's really what the dispute is between our favorite 2 and our least favorite 10. This came up. There were rumblings of this in the argument before Judge Levy in his courtroom. And whoever is the board of directors, they have a fiduciary duty. And in a for-profit corporation where you have shareholders, typically the majority shareholder, they get to call the shots. And in corporations, the majority shareholder has a fiduciary duty to the minority shareholder. and that is to look out after the interest of the minority as if it were the interest of the majority shareholder. So during oral argument, there was discussion that Oregon State and Washington State owe a fiduciary duty to the other 10. But that's not what Oregon State's lawyer was saying. That they're saying that this is a nonprofit and we have a fiduciary duty to the conference. And so that's going to play out. There will be a balancing. So from current revenue, what percentage of current revenues are to be paid to outstanding long-term liabilities? So if George K is fired and we need to have some sort of a settlement with him on the way out the door, you would like that to come out of current revenue rather than whatever may be in reserves or coming in the future into the conference.
Certainly.
And there are 4 or 5 lawsuits. I think one of them may have been settled. Oregon State, Washington State would probably like to settle the rest of them and pay those out of current revenues. And the other 10 are not going to like that. And you are going to see further arguments between the 12 and the 2 and the 10 coming in the future, I am certain, unless they settle before that.
Gotcha. So are you seeing any kind of a partial payout in a future year, like in 2024, to any of the schools that leave? I'm hoping you're going to say no.
Well, no. I think there will be a payout of proceeds from 2023, 2024 sports year or academic year. There will be current revenue that will be paid to the 12. Oregon State, Washington State is not going to spend it all. They are not going to keep it all for themselves. And if they tried to do that, they would be taken back to court and they would lose. So yes, I think there's going to be some payout of current revenue, but I think it will be less than paying out all of current revenue.
Right. So, but nothing coming. You don't see anything like in the new year starting at 1st of August, like, because a lot of this is residual, right? I mean, I believe some of the money we're getting in 2023 is actually from 2021 or something like that, previous playoff and tournament revenue and so forth like that. I believe some of that is there. It takes a year or two for it to actually hit the door.
So the NCAA basketball tournament, there are tournament shares, and you receive 6 tournament shares for each team that plays in a tournament game. So the more games that a university plays, the more shares they get. And I call it 6 shares. It's really 1 share a year for 6 years. And those tournament shares belong to the conference unless the conference dissolves. And I think that's part of the future revenue that they are talking. There's also some future payouts associated with the Rose Bowl, because the Rose Bowl is no longer affiliated with the Pac-12, and instead it's part of the college football playoff. Plus, everyone gets all excited about the participants' share in the college football playoff. And it's going to go from 4 participants to 12 after this current year. And boy, it would be nice to have that money coming in the conference. And that is true. However, the participant shares are dwarfed by the ownership distributions to the 5 conferences that own the college football playoff. And the 5 conferences are the Power 5 conferences, including the Pac-12. So last year, as an owner with a 4-team format, it is reported that the Pac-12 and the other 4 conferences each got $80 million as part of their profit distributions from the college football playoffs. And so for the 2024 college football playoff in January, that money will come in the current academic year, and that money will be divided out, presumably among the 12 conference members. But we have the next 2 years, and the 4-team college football playoff is expanding to 12. And that means you have more games, hopefully more money, more revenue, and more profits to distribute. You may remember a few months ago, someone said there's going to be $300 million a year for each conference, and that'll be split between Oregon State and Washington State. That came from some guy who was interviewed on a Pac-12 a Big 12 podcast. I think the guy called himself immaculate or something.
That would be correct.
And that's just speculation. We don't know what the profits are going to be from the 12-team college football playoff, but that too will go to the Pac-12 and presumably to be divided up between Oregon State and Washington State, or to be spent as Oregon State and Washington State desire. And as to your question, no, I don't think any of that money will be divided to the wretched 10, unless Oregon State and Washington State enter into some sort of a settlement where, in exchange for spending more money now for the future of the conference, maybe they pay out some of that in later years. $1 today is better than $1 in the future. And I mean, that could be creative deal making. But do I think that's going to happen? No, I don't. But it could.
So the last question, as we are officially in Civil War week, I have to call it that. I'm going to call it Civil War. Do you think after this year, I know, look, Washington and Washington State just cut a deal for the Apple Cup to extend it out for 5 years. They play next year at Lumen Field where the Seahawks play, and then they alternate for the next 4 years. There's rumblings that they're trying to do a deal of extending it to the Civil War. Nothing's been announced yet. So what do you think? Is that going to get done? Do you think they'll pay us?
My guess is that if they do a deal, it probably will be a home and home deal. And if it's not a home and home deal, I don't think Oregon State should do it. And hopefully Oregon State won't.
Thank you.
Oregon's going to have significantly greater resources than Oregon State if things stay on the current trajectory. Now, I'm hoping that Oregon State and Washington State, through innovation and vision, can come up with something cool out of the new Pac-X or whatever they call it.
Get Elon Musk to sponsor it if you call it Pac-X, man.
Well, when you weren't too sure about that name, I almost suggested, well, would you like it better if that brought Elon Musk to the table with a streaming deal worth many millions of dollars, tens of billions of dollars for each school?
Sure.
What I don't want to see is the Civil War game devolve into a body bag game.
Oh, 100%.
And for those who aren't familiar with what a body bag game is, Oregon State had a lot of these, particularly during the 28 years of consecutive losing seasons, where they'd go back and they would play Michigan or someone for a big paycheck, but they were so outmatched and they would come back with injured players. The Civil War, that rivalry is too storied for that to happen. There are advantages to Oregon State of continuing the Civil War. Now, I used to do Civil War buttons. I had 7 years. I did a button each year for the Civil War, and they were funny, picking on the Ducks one way or another. And then my vendor broke their button machine, and I quit doing it. But I brought out a Civil War button for this year. Went to another vendor, and boy, they are expensive. But my button says 127, and this is the 127 Civil War. It says 127 and done. And I even sent those buttons to the Oregon State Athletic Director and the Oregon State University President. So we'll see if they're sporting my buttons on Friday. Probably not.
Well, probably.
But there are advantages to Oregon State. One is we need Power Five opponents if we're going to continue to compete at a Power Five level as we try to position ourselves for the next round of realignment. And Oregon is right there. And so, yeah, that kind of makes sense.
Yeah.
And if we can continue to compete at a higher level and find resources, boy, beating the Ducks would be huge in what we're trying to create and what we're trying to lay out. So, yeah, I think there will be games. Should Oregon pay us even for a home and home? Yeah, I think they probably should. But I think they're going to say, if you want our money, then we're going to play at Autzen, and that just isn't acceptable.
Let me throw something out at you before we wrap this up. This is pure speculation on my part, just something for you to think about for the next episode. Oregon State and Washington State win, okay, on the 4th. Stanford and Cal recognize the error of their ways and asked to come back and be part of this reestablished pack, whatever, because they realize just how crazy it is for them to go to the ACC. Because I honestly think that they were afraid that the Beavs and Cougs couldn't pull this off, couldn't win and keep the conference. So they were grasping at straws, taking a no revenue deal with the ACC. So they say, okay, can we come back? And we say, sure, at a very reduced share. But yes. And we've got the 2 Bay Area schools back in. Just something to throw out there. We were chatting amongst friends over a Husky game weekend. So thought I'd throw that.
I think that's highly possible. And it may not be right away, but it may be in a year or two. And they decide this traveling across the country for no money.
Yeah.
I mean, they have valued their participation at 0. The problem is trying to leave the ACC. It has a long-term contract. I think it goes to 2035 or something, and they have huge exit fees. So that is where the leverage of Discovery could help. If we want to reach an agreement with the other conferences and the TV networks that if a former member wants to leave, or a member of one of the other conferences sees the handwriting on the wall and they're about to be relegated, so they would like to come join this upstart innovative Pac X that's doing something different. One of the advantages, though, of having Stanford coming back in the fold is there are reports that trying to do a deal with Apple, Stanford was very important to Apple, and that Stanford's connections with Apple were very important as part of an Apple deal. So we'll see what happens. But yes, I think they're going to want to come back. I think UCLA may want to come back.
Yeah,
after a few years.
They're going to get hammered.
Probably wouldn't want to take USC back. Wouldn't want to take Oregon back. Wouldn't want to take UW back.
No.
Probably wouldn't want to take Colorado back. But no. I would take Utah and Arizona State. Although for them, the issues are a little different in that they don't have the same travel. They're kind of right in the midst of the other universities that are part of the Big 12, but I'd take them back if they want. Hey, we are recording this on the Tuesday before Thanksgiving, which is also the Tuesday before Civil War game. Want to say happy Thanksgiving to Beaver fans, and we I am told that we are also being followed by a number of Cougar fans. And
Hey,
so to the Cougar fans, we wish you happy Thanksgiving as well.
go Crimson. Let's go, guys. Go Coug.
Hey, thanks, Tony. Have a happy Thanksgiving, and go Beavers.
Go Beavs. You too, brother. Take care now.